My name is Leslie Thomas. I'm a barrister at Garden Court Chambers. I'm also a Professor of Law at Gresham College and the Visiting Professor of Law at Goldsmiths, University of London. I've spent my career representing clients in inquests and public inquiries and actions against the state. In our celebration of the European Convention of Human Rights, I want to talk about Article 2 and give a short explanation of what rights are protected by this article and why this article is so important for protecting the rights of the people we represent. In short, Article 2 of the Convention is, in my opinion, the most fundamental of all the protected rights. Why? Because it's about your right to life. Let's face it, without your life, all the other rights pale into insignificance, in my opinion. But Article 2 is not simply a right not to be killed. It includes that, but the article also imposes a positive obligation on the state. There are three main positive obligations. The first is assistance duty. That's the duty to have in place an adequate system to protect life, including the criminal law, and includes provisions that prohibit and punish violent offences. The second is an operational duty. In some circumstances where the state knows or ought to know that there's a real and immediate risk to someone's life, it may have a duty to take reasonable measures to protect that person. This applies, for instance, where the state knows or ought to know that someone is at risk from criminal acts of third parties. Further, in some circumstances, it also requires the state to take reasonable measures to prevent someone from committing suicide, for instance, if that person is in prison or other state detention. And third and finally, there's the investigative duty. This applies where a person dies at the hands of the state, or in other circumstances that engage the state's responsibility. A 2004 case called Middleton, the House of Lords said that compliance with the investigative duty must, and I quote, rank among the highest priorities of a modern democratic state governed by the rule of law, end quote. So this applies to all inquests in the UK, which is how our country investigates sudden and suspicious deaths. Today, therefore, an Article 2 inquest is more expansive than a non-Article 2 inquest and is the primary means by which the state carries out its investigative obligation. So when does the obligation apply? Well, it obviously applies where a person is killed by a police officer or a prison officer or some other state agent, such as a detention guard for a immigration service. But it isn't limited to those cases. It also applies, for instance, as I indicated above, where somebody dies in custody. A number of cases have established both that the state has an operational duty to take reasonable steps to prevent people from committing suicide in prison, and also that if a person does commit suicide in custody, that the investigative duty is triggered. I have done many cases where Article 2 is proven to be effective in protecting such rights. Every death in custody, Article 2 is impacted and triggered. So what does this mean in practical terms? Well, it means that there is legal aid for these inquests because there needs to be equality of arms between the state and those killed by the state. Secondly, it means that there is disclosure. In other words, there is a cards on the table approach so that the families of those who've died in custody know the documents that the state has. Thirdly, the family are put at the heart of the inquest. In other words, the inquest takes into account the bereaved family's needs. Fourthly, the investigation is independent. And fifthly, that the investigation is conducted timely. These principles are really important and have real practical effect. I want to mention just one case that I've done out of the many, and it reminds me of just how important Article 2 investigations are. It involved the death of a young woman, young mother, who was imprisoned and put on remand. She was suicidal and had indicated her suicidal intent to the prison authorities. Despite this, she managed to self-harm on more than 80 occasions, and on the very final occasion, she took her life. There was an inquest that investigated how and why she met her death, and there were a number of criticisms made of the state that prison in reliance of Article 2. The family got a satisfactory outcome with recognition that the prison had failed to protect their daughter, mother. This just goes to show just how important this article is.